speaker tonight is John Barylick. He is a graduate from the Boston University School of Law and a litigator since 1977.
This was a situation where negligence and greed literally overcame concern for safety.
His practice has primarily been representing injured plaintiffs in civil litigation, medical malpractice cases, wrongful death, and catastrophic injury litigation.
So they sponsored the appearance of Great White at the station, and they provided big banners, party with Budweiser and Great White. Two of the members of the NFPA's committee setting the standards on how you use fireworks before near audiences were high-level executives of Anheuser-Busch.
All right, we're joined today by John Barylick, who is the author of Killer Show, The Station Nightclub Fire, America's Deadliest Rock Club Concert. How are you doing today, John?
I'm just fine, Eric. Thank you.
Well, thank you. And you are the second John I am speaking to about this horrible tragedy that took place. And I don't know, is tragedy the right word when there's so much negligence involved?
Oh, absolutely. Negligence can result in tragedy, and that's exactly what we had here. This was a situation where negligence and greed literally overcame concern for safety.
Okay, I always want to be really careful about my terms because there are times, for example, the terrorist attack, people will call it a tragedy. I'm like, no, that's a crime.
I don't think they're inconsistent. You know, the results of criminal or negligent acts can be tragic for the persons involved. And in this case, for the victims, for their families, and indeed for the whole very small state that we have here, it was tragic.
Okay, so are you local to the incident or do you live nearby?
I I do not live in the town, but I live in the state. And as you know, in Rhode Island, nothing is too far away. So, they say 6 degrees of separation. When it comes to Rhode Island, it's about 2 degrees.
Okay, or even one, depending on where you are. So let's talk about that a little bit. In the book, you talked a bit about the town in question. It has a bit of history and legacy with, of all things, fruit of the loom underwear.
Yeah. The town had a history of being a manufacturing center here in New England and particularly in Rhode Island. And among the many mills that lined the river that forms the core of West Warwick, Rhode Island, was a factory for Fruit of the Loom underwear. So for decades, Fruit of the Loom underwear was manufactured in West Warwick, Rhode Island. Of course, in the 1960s, all those industries went south with labor costs, and after that to Asia. So West Warwick was left kind of a shell of its former commercial self by the time of this fire.
Okay, and this becomes relevant because we're looking at a club in the area. It's kind of in hard times. It's not really a modern bastion of music with top-notch equipment. I believe it was originally a spaghetti restaurant or something like that?
Yes, it was. It was, well, actually, very originally, it was simply a bar. And it was a sailor's bar for the sailors in Newport, Rhode Island. And then it became a spaghetti restaurant. And then it became a succession of bars and clubs in this same physical location that by the time of the fire was owned by two brothers, the Dodarian brothers, who had day jobs. This was kind of a hobby for them. And had local bands most of the month, perhaps once a month, would try to bring in a national act. And that's what happened at the time of the fire. It was a national act, Great White, which was kind of an over the hill 80s heavy metal band
Mhm.
that was brought in for a single concert at the station. They set off illegal pyrotechnics within the club. The sparks struck foam insulation on the walls, And within 90 seconds, if you had not made your escape, you stood very little chance of escaping. So it was kind of a perfect storm of rundown club, illegal pyrotechnics, overcrowding, just commercial interests outweighing safety interests.
Now, I don't want to downplay exactly how rundown it was. I think you described in the chain of ownership that the club was almost like an albatross around the different owners' necks. Like they bought it, they had a dream, they found out, oh my God, this is a problem. And they tried to sell it to the next person like a hot potato. And I'm not trying to be funny here, all the way down the line. And before the Darians, didn't the owners actually hide information about the club and debt that was incurred, like back rent and things of that sort?
Absolutely. The prior owner of the club, one Howard Julian, was in debt to his landlord for many months past rent. And in trying to sell the business to the Dudarian brothers, didn't want the landlord to disclose that he was so far in debt. There were just a succession of hapless owners who, as you say, each had their dream, but all of those dreams were dashed until the next greater fool bought into the location.
Now, and I don't want to excuse the negligence in behavior, but this financial situation probably led into it. If you're buying a club, the club is a money pit, you may not invest in top-notch materials to dampen sound, to help, silence whiny neighbors, in their opinion.
That's absolutely true. That it's the marginal locations that cut corners on safety. Here, for example, they put over $60,000 into a sound system. For $35,000, they could have put in a sprinkler system, but that was not a priority. Okay. Just small decisions like that added up to tragic results.
Okay, now I've spoken to, Pyro John Watkins before, and if I remember to do it, folks, there will be a link above John's head on the, top right if you wanna click right over and see that. But, John broke down what went wrong, and I think that that's a great pattern of what were the elements that led up to this horrible night.
Well, the interesting thing here is that it was no single element of negligence, but there's enough blame to go around to numerous parties. And each of these little lazy missteps or greedy missteps created a critical mass that eventually caused this tragedy. To list them, I mean, illegal use of pyrotechnics to start with by the band, improper use of foam plastic as sound insulator on the walls, exposed foam plastic, overcrowding of the club, absence of safety devices such as automatic sprinklers in the club, inflating the maximum occupancy of the club, overcrowding it that way.
Now let's
The
can we delve into each of these a little bit as we go?
Sure.
Like, okay, you mentioned the sprinklers. Now, a lot of people say, "What? Why?" That makes no sense. Wasn't it legally required in a venue where you're going to have a bunch of people that you have to have sprinklers? Why
You
didn't they?
you would think so, but in most state fire codes, there is the capacity for what's called grandfathering, and that is if when the building was built, the codes did not require sprinklers in a place of public assembly, then as long as you didn't change the use or occupancy of that building, the lack of sprinklers was grandfathered in. The interesting question here is if growth from a restaurant seating 50 to a nightclub allowing 400 people in standing room is not a change of use or occupancy that would require sprinklers. I don't know what is.
Yeah, that was my question because I was thinking that a restaurant is a different type of environment than a club with people crowded in together in a small area. And like you said, a band on stage using pyrotechnics or whatever else. I don't know if a restaurant would have been under the same threat. I'm not saying it couldn't have caught on fire, but obviously kitchen fires and things like that happen. And there are restaurants that burn down all the time, but I don't know if there would have been as many people harmed.
That's certainly true. Uh, this was a failure in code enforcement for sure. I mean, this was a change in use or occupancy that should have required it to be sprinklered. There also, the very presence of that flammable foam on the walls was a code violation. And during the annual fire inspections for this club, that should have been cited and required correction. But again, economics come into it. The use of that foam was very important economically to the survival of the club because neighbors constantly complained about the noise. And this was a ham-handed attempt by the owners to address the noise problem. So if they took that foam down to comply with the fire code, it might have been the end of the club. So for whatever reason, the fire marshal, Dennis LaRoque, overlooked the presence of that foam for 3 years running.
He also, from my understanding, overlooked or there was a problem with a door that opened one direction or another, and they had a bit of a dance. Can you describe that so I don't mislead?
Yes, there was a door that had quite a history and played a part in this fire called the band door. It was to the right of the stage, and it was the door through which bands and their entourage would load in and load out. Unfortunately, that door was right next to a housing development, and there were always noise complaints. So, in an attempt to muffle the sound, they created a double door, earlier owners, a door that opened outward and a second one right against it that opened inward. And as you know, under fire codes, you can't have an egress point with a door that swings inward. Well, it didn't play a part in the fire in limiting exit, but its history shows something about how the fire code was treated. And that is that in the 3 years prior to the fire, the fire inspector came through and he said, well, this second door opens inward. It's a code violation. And the owner would take the door off the hinges, have the fire inspector come back. He would check off that the problem was solved. And then the owner would rehang the door. And this happened 3 years running. So you'd think by the second or third year, they'd get an idea that the code wasn't being treated too seriously here. That's one of the interesting stories about the stage door. The other interesting story is that because of the noise problem, the Dudarian brothers imposed on the bouncers a band door rule, if you will. And the rule was twofold. If there was music being played, that door would not be opened. And the second was that only people who were with the band were allowed to use that door. Now, that's fine during normal circumstances, but when you have an active fire working, bouncers should not turn people away from that door. And they did that night to some people's death and other people's serious injury.
That I hate to label and say greed and things like that, but it does come across that way. Seemed to come across even during the incident. I believe the Dudarian brother who was on hand, rather than checking on making sure people were flowing out okay, is it true that he grabbed the cash register in order to get the money out and hide it somewhere in the forest or whatever was nearby?
There is evidence that Jeffrey Derderian, who was present at the club that night at the front desk, was handed a cash drawer by one of his employees, and that Jeff went to the back of the club and stashed the cash drawer in a snowbank. Uh, it certainly was a strange priority as people were jammed into the front entrance and tumbling out of windows on fire. Uh, it bespeaks the mindset of operating this club, unfortunately.
And It's an odd touch of irony, I guess, because Daniel Bashil, I believe, is the one who actually lit or set up the equipment and the pyro, etc., and could be seen as the ultimate spark who started the fire. But he was attempting to help people, from what I understand.
Absolutely. The road manager for Great White, Dan Beakley, yes, he was the person who physically connected up the pyrotechnics and flipped the switch, albeit at the direction of Jack Russell, who was the head of the band, lead singer and head. Uh, of anyone, he, at the scene of the fire and thereafter, manned up and tried to help as many people as he could and never shied from responsibility. Uh, he pleaded guilty to criminal charges that were brought against him when, in fact, no criminal charges were brought against Jack Russell, whose decision it was to use the illegal pyrotechnics. So he comes out of this as kind of a tragic figure.
He really does. Now, he served time, and the other Dadarian brother served time. Why is it that Jeff Dadarian, who was on site and seemingly would be ultimately in charge of the venue, he did not serve time?
He did not. This was part of a plea bargain that was struck with by the Dudarian brothers with the Attorney General. I was dealing with the civil side, so I was not privy to the negotiations. People were a little shocked that the brother who was on site that night only did probation, while his brother served some 27 months, I believe, in minimal minimal security. Uh, I don't know, Jeff had young children at the time, and it might have been that Michael, agreed to somebody had to serve time, so he would volunteer that. Michael, interestingly, did the pre-concert planning for this gig, and it was he who participated in the preparation of the planning sheet, and if you look at the written planning sheet for this concert, a document prepared by Dan Beakley, of the road manager, there's a space and it says pyro question mark. And it was typed in yes. Well, that would have only been typed in yes if Michael Durdarian in the planning had agreed to it. So,
I'd say.
in terms of culpability for bringing in the illegal pyro, I think quite a bit of blame lay with Michael on that. But you're right. It's illogical that these three men, Beakley and the two Dudarians, are charged criminally, but neither the fire marshal, who let that foam remain on the walls over 3 years, nor Jack Russell, the head and decision maker of Great White, were ever charged.
Is the fire marshal off the hook because I forget that there's a basic immunity for public figures?
There is a specific statute in Rhode Island that provides the fire marshal with immunity from criminal or civil prosecution for actions undertaken in the performance of his duties in good faith. Okay. Now, I wasn't privy to the prosecutorial discretion that resulted in his never being indicted, but I can't help but think that that statute played a part in it. As morally culpable as he was, I don't think the elected attorney general wanted to see him get charged and then get off on what some people would regard as a legal technicality. But we as civil attorneys look at good faith a little differently. And when you rate an entire club as standing room, and when you allow this solid gasoline to be on the walls for 3 years running, that's not what we regard as particularly good faith on the part of the fire marshal. So we didn't think that that statute stood in our way civilly from suing either the fire marshal or his two superiors that he reported to, that is the town of West Warwick and the state of Rhode Island, as a deputy fire marshal.
Well, and I host a panel with lawyers every week and hang out with them. there's also the factor too that a criminal charge is far greater of a burden than a civil liability, correct?
Exactly. The burden of proof for guilt in a criminal charge is the one that we hear on television all the time, and that is proof beyond a reasonable doubt. In the civil context, the burden of proof is what they call by a fair preponderance of the evidence. That is, weighing the evidence like scales of justice, does it tip to one side or the other, however slightly?
And is it that way because of jeopardy? Like in a civil case, you're not going to prison. You're not going to lose your freedoms, things like that. You can lose your house, your fortune, a lot of money, but you're not actually losing your freedom itself.
Exactly. And well, if the criminal system and the civil systems do overlap in their objectives somewhat, one of them being deterrence of bad conduct.
Mhm.
For the most part, while the criminal system seeks to punish and deter, the civil system seeks to make whole as well as money can. So they're very different objectives, and you're right. Much higher burden of proof for criminal.
Okay, so now can we talk about how did you get involved? First, how did you hear of it and what brought you into the case?
Well, I first heard of it like most people. I was looking up at a television monitor. I happened to be on my way to another city, and I was in the airport in Providence looking up at the news scroll on the TV monitor the next morning and seeing the death tolls being reported larger and larger numbers. I realized this was going to be a horrific event for the state. And because our firm had long been involved in complex plaintiffs litigation, it was inevitable that the phone would start ringing, and it did start ringing within 24 hours. Many general practice attorneys referred those cases to our firm, and before long, we were one of 9 firms, 8 or 9 firms in the state that formed a plaintiff steering committee to try to coordinate and bring some order to seeking civil relief against the many people that were arguably at fault here. So the civil litigation went almost in a parallel track to the criminal litigation brought by the attorney general.
Now, I have a question on that, and you can get into the weeds with me a little bit. I hope because are there sometimes problems with that where civil has to take a back seat because um, I'm going to go in a weird place, but Bill Cosby was civilly charged and a deal was made with the DA saying, "Hey, you could testify in the civil charge, won't be held against you on the criminal." Turns out, no, it was held against him. I might not be perfectly on track, but he wound up being released from prison because of this. Is that something that you had to deal with it while you were in a parallel track? You kind of had to take a back seat for the criminal side until that was resolved. Can you talk about that?
Well, you have to there's a process in civil litigation called discovery, where you get to propound questions, interrogatories, you get to seek discovery of documents, and importantly, you get to take depositions of witnesses. Well, here you had major central witnesses, Beakley and the Judarian brothers, who were under criminal indictment. As much as we would have liked to have taken their depositions, they dare not testify in the civil matter lest they waive their Fifth Amendment right in the criminal prosecution not to self-incriminate. So you're right. The civil litigation has to kind of take a back seat in their discovery until the criminal cases are resolved.
Okay, so and from what I understand, yeah, in the deposition, they have to be forthcoming. And
They do.
that is a giant problem with the criminal side, where being forthcoming could be, detrimental. So, were you able to get the full depositions after the criminal, case was resolved?
Actually, we didn't need to
Oh,
because
okay.
we were able to get so many depositions of other participants, whether they be uh, sellers of insulation or prior owners of the club or prior employees of the club, that we were able to develop our proofs uh, even after we didn't have to wait till we got depositions of the individual criminal defendants. Now, our cases, the civil cases, fortunately never had to go all the way to trial because we were able to develop our proofs, go to a process called mediation against the major defendants. And that mediation attempts to be a forum where the plaintiffs can disclose what they've got and the defendants can kind of argue to the plaintiffs how they disagree with that. And then a mediator goes between the two groups to see if he can reach a common ground on what a fair settlement would be. And we were able to do that with the major defendant groups instead of go all the way to trial.
Okay. Now, one big question I have is, I believe the term or the money floating around was $176 million in settlements. Um, Jack Russell had declared bankruptcy. Great White wasn't even Great White. It was Jack Russell's Great White because the band itself was kind of fractured, I believe, at that point, according to Pyro John. Um, the the Darien brothers couldn't have been that wealthy. One was like a newscaster in the club. They're already neglectful on, fire sprinklers and things like that. So I don't know what kind of insurance they were. So I guess this is my long-winded way of saying, where the hell did the money come from?
That's an excellent question. And frankly, that was the question that referring attorneys were asking us. They were saying, you'll be able to develop liability theories and huge damages, but who has the resources to respond to a judgment of this size? And in answer to your partial question, that is, what did the insurance look like? The band, even though it was an iteration of Great White, had a policy of liability insurance for $1 million. The club owners had another policy of liability insurance with $1 million policy limits. That was pretty much it.
I was going to say that's 2,174 to go.
Yeah.
Okay.
And in a case where there are 100 deaths and 200 injuries, some of which
Yes.
are absolutely catastrophic, $2 million doesn't go very far.
No.
So we had to look to much more peripheral defendants who, while not as clearly culpable as the band or the club owners, had some responsibility, but they were in a better position to respond to a judgment against them.
How about the pyro manufacturer who sold it? Can you break down what happened there? Because there was some, from what I understand, shenanigans going with the sale of the
Yes.
pyrotechnics.
One of those additional, more peripheral defendants was the manufacturer, wholesaler of the pyrotechnics company in Alabama, I believe.
And who
And
was that?
I'm sorry,
The name of the
the,
company and all that?
I think it was something like American Pyrotechnics, or I,
Okay,
I,
no,
I can check it if you'd like here. I can look it
that's
up
okay.
very
That's
quickly.
that's okay.
Uh, High Tech Special Effects Inc. was the name of the company in Alabama. And they, being a manufacturer of fireworks, have to be licensed by the federal government. And they had a license to manufacture fireworks. And that license requires that they sell their grade of professional size fireworks only to licensed pyrotechnicians. And in doing so, every sale had to be accompanied by a data sheet, a federal form, where they fill in the identity of the licensed pyrotechnician to whom they're selling. Well, in this case, as in several others, High Tech Special Effects simply sold to whoever wanted it and filled in the name of a licensed pyrotechnician.
It's not just an insurance issue. I think that's called fraud.
Indeed, it was. And this company, shortly thereafter, lost their federal license, uh, went out of business, and the president was shot and killed. It was a very checkered history company.
What happened with the president? Again,
I
what
think it
happened there?
was a disgruntled ex-employee or ex-partner. I don't know the details of that case, but I do know that within about 10 to 15 years after the station fire, that president lost his life. The
Wow.
That fireworks company had, I believe, something like $6 million in liability insurance,
Okay,
which
but before we dig in too far, but
sure.
I'm not an insurance expert, but wouldn't the insurance company say, no, this is a fraudulent transaction. We should not have to pay because again, we're getting into the good faith question. So, please help me out on that. How, or am I wrong? Did they say, oh, no problem, here's the money, or did they
Mhm.
fight it? Because I would think they'd fight it.
Well, most liability insurance policies have an exclusion for intentional bad acts. Okay. You have a liability coverage under your homeowner's comprehensive policy.
Sure.
And if you negligently or maintain a negligent condition on your property and somebody is injured, they will pay. If you go out and bop somebody on the head on your property wrongfully, uh, it's not going to cover that. Here you had a fine line between whether the pyro company was just plain careless in having some clerk fill out or whether there was knowing fraud at a high level. But given the catastrophic scale of this loss, the pyro company couldn't afford to not tender its insurance policy in settlement to avoid the possibility that we could get a judgment against the company for much, much larger than the $6 million to the extent that they had any assets whatsoever. So, yeah, that's why the insurance company settled on what kind of had tinges of fraud in it.
Is it also because it's such a horrible, gruesome event that the PR, if they didn't, might have just been not worth it to them? They'd be like, "You know what? Let's just pay that out," because of, the horrible, tragedy that it was.
I think that was true for they and many of the defendants in this matter, that they certainly didn't want to be associated with this event by their product or by their conduct. So, yeah, the very horror of it probably motivated settlement. This was not a fender bender.
Okay, so now, I hate to be an accountant here, but now we're up to $8 million,
Yep.
168 to go or something like that. What else?
Well, one of the other major defendant groups was manufacturers of the egg crate polyurethane foam that was applied to the walls of the station. Comes under the category of what's called product liability in the law.
Okay.
And the theory there is that they sold a product that was defective and it caused injury. Now you say, well, wait a minute. It was defective, but it was apparently misused. This was
I was
packing
gonna say,
foam
yeah,
that
if it's not
someone
a
put
use
up on
case.
their walls. And under the law, generally misuse is a defense to a product liability.
Mhm.
You can't go out and buy a Craftsman rotary mower, use it to cut your kid's hair, and complain that something bad happened. But there are
Good
certain
analogy.
situations where a misuse is so known and it's so readily foreseen that you have a duty to warn. And here, in this case, you had a duty to warn that this is not a building material. It's not something you should put on your walls or expose to fire or flame in any way. And we were able to marshal evidence that the foam manufacturers really they knew about its misuse and they should have put more warnings on it.
I see. So, just to rephrase that for the rest of us, is the argument that it is such a popular, known application of this material that this isn't the only club that's done it, that it's done in a lot of places, and the manufacturer had knowledge of this?
Not only do we have evidence that it was known in the industry, but if you go back to the advertising brochures of the main polyurethane manufacturer defendant here,
Mhm.
they brag that this substance can be
Oh,
discarded and reused and recycled. It can be used for sound insulation,
boom.
you
Okay.
know? So if you advertise in your brochures, use your imagination, it's not a big leap for somebody to say, I put it on the walls of my loud club.
No, no, no. If they advertise sound, then they're done.
Yeah,
That was a smoking bullet, I'm sure,
it really was.
or smoking gun. Sorry. Anyway, all right. So we've got that. Who else?
Oh, well, uh, one of the defendants that contributed a substantial chunk, another 25 million to the global settlement fund, was the employer of a cameraman, a TV station cameraman who was present in the club during
Mr. Butler.
Mr. Butler, during the concert, who early on realized that there was something very bad happening. This was shot by a cameraman for a local TV station. You may say, well, why was there a cameraman from the TV station inside the club that night? And the reason is one of the club owners, Jeffrey Derderian, had a day job, and that was as a TV reporter. 3 nights before, there had been a tragedy in a nightclub in Chicago, and he thought it would be great to do a story on, of all things, nightclub safety. And removed himself to a position of relative safety near the door, and then, according to several witnesses, held his ground for a period of time to continue to get the shot while impeding the egress of people. Okay, we were able to marshal evidence of that we took to the mediation with his employer, the television company that employed him, and strike a settlement that they didn't want a jury to see that he was bragging to his producer that he got it all on tape from inside, and we had a
Mm.
recording of that. Okay, it
Oh,
really sounds like somebody who was hanging in there to get the shot. So that
and
was
that
another deep-pocketed defendant who contributed to the global settlement.
okay, and I had no idea of that. So that makes sense because their image is worth a lot of money.
Exactly.
Wow. Okay, so now we're starting to actually get into some of the deeper pockets. And any other notable
Well, the 2 of them, one was a second kind of foam. You know, if you look at the Brian Butler video, you see the sparks hit the polyurethane foam and immediately catch fire. But our fire experts looked at the video and saw that this fire was being fed by some kind of hydrocarbon product, much more than the polyurethane foam. And we came to learn that underneath the polyurethane foam within the drummer's alcove was 2.5-inch thick polyethylene foam that had been put on the walls by a prior owner of the club. And then the Derderian brothers simply glued the polyurethane on top of it. So we were able to discover the most likely seller of that polyethylene foam and document a claim that they should have known that the product was inadequately labeled and they should have foreseen its use as a sound foam and not put on walls where it might be exposed. So that industry group was another large contributor. There was kind of a strange contributor to this settlement, uh, and that is Anheuser-Busch, the big beer company. And you say, well, wait a minute, you plaintiff's lawyers, what? They didn't light the fire. They didn't overcrowd the club. What, the beer company? What possible liability could there be? And the story behind that we came to learn was that at the time, Anheuser-Busch was selling a marketing gimmick that they called born on dated beer. You may remember that gimmick. So they had, they sponsored the appearance of Great White at the station, and they provided big banners, party with Budweiser and Great White. And they sponsored their appearance around the country, and they paid for the appearance of an MC who we claim controlled the stage while they were setting up the pyro behind him, so he could have stopped the event. But beyond that, this pyro was shot off in violation of published standards from the National Fire Protection Association, the NFPA. And those standards were set by the NFPA's subcommittee on use of pyro. Now, this is really in the weeds, but it's kind of neat because at the time of the fire, two of the members of the NFPA's committee setting the standards on how you use fireworks before near audiences were high-level executives of Anheuser-Busch. And if they had looked at what the band they're sponsoring was doing around the country, setting off illegal pyro in violation of the standards they were setting, it, they could have put a stop to it. Now, you may ask yourself, why did a beer company care about pyrotechnic regulations? And the answer is Busch Gardens. At
Oh,
the
right down the road
time,
from me.
at the time, they owned the theme parks, which
Right.
are the second highest user of pyro to Disney in the country. So they wanted a hand in setting the standards. And yet, here they were sponsoring the appearance and paying for the MC at the station when illegal pyro was set off in violation of all the standards they set. So it's a little convoluted, but when you ask, how'd you sue the beer company? This is why Anheuser-Busch put up 10 million and its local distributor, I believe, another 10 million. It may have been 5 and 5. It's been so many years since the litigation, but they put up a substantial amount toward the global settlement fund.
Okay, I want to know who was the clever individual who figured out, or individuals who figured out these angles, because there's some very creative thoughts going into this to look and dig and find that money. Who was responsible for figuring that out about Anheuser-Busch as an example?
I'd like to say that I was personally responsible for it all, but I wasn't. Okay. Our firm was co-chair of the plaintiff's steering committee, which combined the resources of 9 law firms and parceled out responsibility to research each of these defendant groups. So one of the large firms' sole focus initially was to research as much as they could about the beer company that was promoting this. And when you stumble across something, the internet is a wonderful thing. And you stumble across how the that subcommittee of the National Fire Protection Association is populated with the executives of Anheuser-Busch. That's an aha moment. So that firm scored that. Another firm was tasked with uh, investigating the flammability and the market share data for some of the foams. You know, another firm was tasked with trying to reconstruct the activities of the cameraman, Brian Butler, by reconstructing from his video and syncing sound to that we had from some witnesses to pinpoint where in the club he was at each moment in time. So these research tasks were tasked out to the various participating law firms. And uh, I had tangential involvement with just about all of them, primary involvement with some of them, but I'm very proud of the creative lawyering that was done in that respect.
Now, I don't want to. I want to shift away from the money, because that, obviously is really important. But I want to know, how about the survivors and the victims, and how did this money help them, or did it? I mean, were their medical bills covered? Were they given any kind of relief? Can we address, really the most important people, in my opinion, in this situation?
Right. That fund of $176 million was administered by a, if you will, an allocation system, a point system that was created by what's called a special master. This is a lawyer type judge who was appointed by the federal court to develop a system to try to allocate this money fairly over the families of people who died and the surviving people who were injured, some catastrophically injured. And even given $176 million,
It's not that much.
there's not everyone can't be fully no one could be made whole. And frankly, when you meet some of these people who are survivors, burn injuries are absolutely horrific and debilitating and disfiguring. No amount of money would you take to suffer those injuries, okay? But the special master developed a point system that, depending upon whether a person who was killed left a spouse or surviving children, and depending on what their education level was, these kind of factors would give them a different number of points to be applied toward the totality of the settlement to allocate their particular share. And you asked about medical bills. The special master, settled on a method for allocating money to injured people that used the amount of their medical bills as the touchstone, as very rough gauge of the severity of their injuries. So if a person had $3 million of medical bills, they would have a high number of points. If they only were treated at the emergency department for some smoke inhalation, they had a very small number of points to be applied against that corpus of money. So uh, that's how it was allocated. It's always difficult because you have to have approval and buy-in by everyone. And everyone thinks that their loss is more significant than others, perhaps.
Well, true. And how many people are we talking about? Because it's victims and survivors. You're talking about almost 400, I believe, right?
Well, yes, you are. We were over 300 in terms of death victims' families and injured people. But we eventually had everyone sign on to the settlement point allocation because, frankly, unless everyone agreed, no defendant was going to settle. They had to know that by paying this money, they were buying peace from everyone. So we finally got unanimity among all of the involved parties, but it took 7 years. I worked on one case for 7 years, and for the longest time, it was an albatross. Uh, one of the most difficult things I've ever done. And all the time, you have to be sympathetic to these people who lost a loved one or a provider or who were horrifically scarred. And you couldn't lose sight of that. It's not just dollars and cents.
From what you said, I mean, just to be blunt, I don't think anybody was made whole or
I
even close.
I would not disagree with that.
And I always want to point that out because we look at this jaw-dropping number, 176 million, but when you cut that up 300 to 400 ways, we're talking about a relatively minor figure. And I'm wondering if there are some people who didn't even have all their medical bills completely covered, if they had to get assistance from the state or things like that.
Well, as you know, initially, everyone's treatment is paid for by whatever insurance they have or whether it was by the state. Okay. Fortunately, those, whether it be an insurance company or the state, were very judicious in seeking what we call subrogation or a lien. That is to recoup money that they paid out from the settlement with the third party before the poor injured person gets anything. So absolutely everyone had their medicals at a minimum covered. Okay, that I can assure you. Uh, what global settlements like this tend to do is overcompensate the least injured in order to get them to buy in, and necessarily undercompensate the catastrophically injured, who, if they had an individual case against a defendant who had very, very deep pockets, could likely recover a little more. But settlements like this achieve certainty for these victims. They achieve a resolution within people's lifetimes, because this could take forever. And they also eliminate the risk that the first people to go to trial would dissipate the resources of those defendants, and there'd be
Mm.
nothing left for the later people in line. So this kind of settlement allocation system is really the fairest way to get a certain resolution for those victims.
Okay, so now moving forward from the victims and the survivors, has this done any good to prevent this? So we don't have to have as many settlements like this in the future. I mean, I'd much rather never have a fund, never have the incident to begin with. How has this helped change things?
It had a striking effect on both the enforcement of existing fire codes and the revision of fire codes in a number of states. Rhode Island certainly uh, increased its enforcement, but it also lowered the number that were required in a place of public assembly before sprinklers were required, for example.
And what is it
Okay.
now versus
I
then?
think it's like 300 now. Okay. It, but in the excitement and the concern after the station fire, that requirement was greatly tightened up. And then a few years after that, it was somewhat relaxed, because it's always a cost benefit thing. And when you have a tragedy, people are willing to spend the money. As memories fade, they become less anxious to spend money on prevention. Okay. But this happened in many states. And I frankly spent the end of my active legal practice career giving presentations to fire safety and fire inspector groups throughout the country and in Canada. And I have to believe that this had a real chastening effect on states and communities in terms of code enforcement. When you talk to uh, fire protection and fire service professionals, these are a unique breed of people, and they're usually pretty macho guys. And they all went into the fire service because their father or their uncle, they always wanted to be a firefighter. And the unique thing is, I've talked to so many of these guys that say, I wanted to be a firefighter from the time I was 14 years old.
Mm.
And of all the guys I've talked to, not one have said to me, when I was 14 years old, the part of firefighting I really wanted to do was code enforcement.
No, I'm sure. And they're not the
Okay.
most popular people around because sometimes codes can seem to be a little heavy-handed.
Exactly. And yet they're under political pressure. They're under money pressure. I've met, people come up to me after a presentation and say, I'm the fire marshal in this town in Iowa. And let me tell you about the political pressure I was under from the town council to give this restaurant a free pass, you know? And I thought back about the station fire, and I sure didn't want that to happen on my watch. So I think it had a salutary effect.
Now, for the code and laws, they're not quite the same thing, correct?
Well, fire codes and regulations are a form of law. Okay. They are a civil violation that people can be cited for, and certainly they can shut down your business if you don't comply. They can't send you to jail for violating a fire code. If you willfully do so, you could perhaps be convicted of the crime of manslaughter. So, there is some intermeshing, but you're right in saying the crime is manslaughter, you know?
Okay. I was just trying to think of how to take some of the choices out of people's hands. Like, yeah, where you mentioned the fire inspector who comes to you and says, you don't realize the political pressure,
Mhm.
Is there a way to arm this individual to where he can, have a shield against political pressure and say, you know, tough shit, I've recorded this meeting, you're now liable.
Okay. Well, one of the shields is that statute you mentioned earlier, and that is the immunity of the fire marshal when he shuts your business down. The original purpose of that statute, the immunity statute, was not to immunize someone like the inspector in this case who overlooks something. It's to immunize the inspector who sees a persistent problem and shuts your business down and doesn't allow you to sue him for it. That's what it's really designed for.
Okay, so does it need to be clarified maybe? Is the
I
statute need to be
agree.
rewritten to really express that it's for the protection of them performing their tasks or enforcing the codes versus neglecting to enforce the codes?
That is absolutely a fair desire. I will state reluctantly that the code, that statute remains unchanged in Rhode Island since the station fire. The one adjudicated case involving that statute was the mirror image of it, where someone tried to sue the fire marshal for shutting down their business. And they said, no, the statute bars that. So clearly that was the intent of the statute, but given its present wording, it kind of got used the other way.
Wow, which is tragic now. John, I always like to wrap up with one last question, which is some find difficult, some interesting, but it can be one of two. Either what is the one question I should have asked you but I neglected to, or as a variant, what is one question you've done a lot of interviews through the years, things like that? It's one question you've been waiting for somebody to finally ask you.
I think the most useful question that people do ask is, a lot of people go to concerts. A lot of people go to clubs. What can I, as a concert goer, do to try to ensure that I'm never a victim like this? And my answer is, if I may, that you've got to be your own best fire marshal. When you go into a venue, whether it's a club, whether it's a bar, or whether it's a big professional venue, some of these stadiums, you've got to ask yourself, what elements can I control? I can't control what they do in the show, but I certainly, in going in, can observe my surroundings. Do the people look like they're well trained who are running this event? Do the people who scanned my ticket look like they would have the foggiest idea what to do in the event of an emergency? As I'm going to my seat, everybody looks for their seat. They don't look around. But on your way in, look around and see where the nearest exit is to your seat. It is probably not the entrance you came in by. Okay. And share that information with your party and just say, if anything goes down, whether it's a fight or a fire or a stampede or a crush, that's the exit we're heading for. And don't let attention to the event or attention to personal property or getting your jacket or your drink delay you in the least. You and your friends head to that exit. You be the first ones out and read about it in the paper the next day. But be alive to do it.
Wow. As a follow-up, and you can confirm this or not, if you go into a place, would you agree, and it just doesn't feel right, leave?
Absolutely. Maybe I was hypersensitized after working for 7 years on this case and living so closely to the victims. But in the years thereafter, I'm not a big club goer. I'm a little old for that. But I was in some venues that I left because it just didn't feel right. I went to one in Oregon, and it was a bar club in a little ski town. And they we were led into kind of a back area to meet our friends. And as I'm led into this back area and we're crowded cheek to jowl, I'm noticing how long it took me to get to the back area. And then I look around and I don't see any regular exits. And I say, well, in the event of an emergency, I wouldn't even move as fast as I did going in because everybody'd be in a crush. And I didn't stay for a minute. I made my way out. Yeah, I missed the show. I missed having fun, but I got away with my skin. So you've got to be able to go with your gut. As you say, if it feels wrong, get out.
Now, while I was researching, I ran across an interview I believe you guys did. I don't know who said it. It was you or Pyro John or whomever, but I just wanted to add this in here and see if you agree. If you were getting on a plane as you're going to your seat, don't wait for the flight attendant to do the lecture. Actually physically touch or feel exactly how many seats away from the exit you are, because if the smoke fills the plane, you will not be able to see anything, and that count could save your life potentially later just by touching the seats to get to the exit.
That's absolutely true. The only survivable plane crashes are those that make it onto the ground in some form, and those that aren't survived on the ground are usually lose their life due to fire. Uh, the No one pays attention to the safety lectures, so you're right. Spot where the nearest exit is to your seat, count the rows. Uh, we all see smoke in movies. I say smoke in quotes. It's not real smoke. And in movies, people emote and give their lines amidst what looks like smoke. Doesn't really happen that way. Most of these products of plastic burning are so caustic and toxic that your eyelids reflexively shut. And you get a lungful of this stuff and you're down. So you have precious little time. That advice to count your seats as you enter the plane, very good advice.
Awesome. And all you soldiers out there who have gone through basic training, one of the things we have to do in basic training is go into the CS chamber, just tear gas. And you literally walk in, you have your mask, you got to look around. When you take your mask off, it's over. Your eyes are shut. You have more mucal fields flying through than you've ever realized, and you're just dying to get out. And I imagine it's probably similar to that. Everything's just clogged up. You can't see anything, so you're just blind and feeling to get out. So,
It's even
John,
beyond that, that the lungful of the plastic toxic stuff is knocked down.
hmm,
Once those byproducts hit your brain, you're out.
oh wow,
Yeah, it's beyond tear gas. Yep.
that is so scary, John. Thank you so much. Now, people also who want to know more about this, obviously, I have a link to the book down in the description, Killer Show. But there is also a documentary that is it took place, I believe, 2013 or 14, somewhere in there. America's Deadliest Rock Concert, the guest list, and it's on Tubi. I believe Tubi is free, so everybody can watch that in their own time. And John also did a lecture on YouTube. I will have all these links in the description, called Killer Show. He did this in front of a tort committee, or was it the Rhode Island Trial Lawyers Association?
Actually, that was a presentation at the American Museum of Tort Law in
Okay,
Connecticut,
thank you.
where I was invited to speak. Yeah.
Wonderful. Well, John, thank you so much. This is great info.
That's my pleasure, Eric. Thank you.